Hello friends, welcome to our channel Legal Nexus. In this video, we are going to discuss about assault and battery, two important concepts under the law of tort. Though often used together, they are distinct wrongs with the different legal elements. Assault means unlawful laying of hands on another or an attempt to do a corporal hurt to another coupled with presentability and intent to do the act. Assault is defined in the section 351 of the Indian Penal Code, section 130 of PNS. If any person make any gesture or any preparation intending that gesture or preparation will cause another person present to apprehend that the first person is about to use criminal force, then the first person commit an assault. In simple terms, mere words do not amount to assault, but the words which a person uses may give to his gesture or preparation such a meaning as may make those gesture or preparation amount to an assault. In assault, a person is put in a fear of violence. Mere verbal threat is not assault. The person committing the assault must have the present ability. Essentials to assault. There are three essentials to constitute assault. The first one is there must be some gesture or preparation to constitute the threat or force. Such gesture or preparation must cause reasonable fear of violence. Such wrongdoer must have the present ability and intention to cause the harm. The intention need not be actual. If reasonable fear of injury or violence is caused in the mind of plaintiff, it is sufficient to constitute the tort of assault. Important cases related to assault. R versus S. George. A points an empty gun towards X. If A knows that the gun is not loaded but B does not know it, then A commits the tort of assault. Morris Marsden. Morris was assaulted by a lunatic called Marsden. It was proved that he knew the nature and quality of his tortious act, and hence he was held liable for the damages. Let's move forward to battery. It is a direct intentional application of force to the body of another individual without his consent or lawful jurisdiction. Explanation. It includes touching a person in a rude and angry manner. The force of touching may be even very slight. Any blow, whether inflicted with hand weapon or any other mechanism, constitute battery. There is no battery if there is no act by the defendant. Khadar versus Alakasamy. An important case related to battery. A police officer put handcuffs and chained and under trial to a window is an hospital during his medical treatment. It was held that the police officer was held liable for battery. Hearst versus Picture Theatres. The manager threatened forcibly knocked out a spectator from the theatre under mistaken belief that the spectator had not paid a fee for his seat. The court held that the spectator was entitled to recover compensation from the manager under the tort of battery. Assault and battery may be justified in the following 8 cases. Self-defense, defense of one's property, to prevent a forcible entry or seizure of cattle, exercise of parental or quasi-parental authority, voluntary non-fit injuria, preservation of public peace, legal process and inevitable accidents. Its most serious injury next to death. If a person is deprived of fight, limb for example, hand, leg, finger, teeth, it's called mayhem, and an actionable can be maintained against such a tort. In assault, battery